Yeah, I'm going to the TV guy.
You know what, though? See, I had short memory, so I did have symptoms. But I didn't have, I wasn't gaslit, or I had no other symptoms. In fact, the only, I was going to...
He sent me some text that his dog ate his homework or something.
I tried to look at a 15-minute pace, 15-minute mile pace, and I've had no trouble.
Ready?
I was walking out to get my
Guys
newspaper.
ready?
My driveway is a very, very slight grade.
Ready?
Okay.
And I was huffing and puffing. Yes, sir. So I said, and one of the nurses down at the gym is the one that said, get your ass to see your doctor. He's the one who discovered I was a native. I had no idea.
Good evening. Welcome to the December 1st, 2015 Murrysville Planning Commission meeting. Please all rise for the Pledge of Allegiance. I pledge allegiance to the flag
of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Penny, please call the roll.
Here.
Yep.
Here.
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 Here. Here.
This is a workshop meeting tonight of the Planning Commission to discuss the proposed ordinance 93015 regulating unconventional oil and gas drilling in the municipality of Murrysville. Well, this is not, they didn't come out for pizza and wings tonight, did they? Okay. It's unusual for us to have a good crowd. It's nice. Before we get into this, listening to all the people who want to speak, I'd like for Mr. Cohen to kind of just give us a brief overview on how we got to this point.
Sure. Thank you, Mr. Chairman. Why are we here on this wet, wonderful evening? And I'm glad to see so many of you coming out tonight. The council in October adopted a draft ordinance, meaning adopted a resolution for a draft ordinance to authorize it to be sent to the Westmoreland County Planning Department and the Murrysville Planning Commission for required comments. This is part of the procedure for amending a zoning ordinance per the Planning Code of the Commonwealth of Pennsylvania, as well as our municipal ordinance. Council cannot act or hold a public hearing until such time, in this case 45 days, has elapsed to receive these comments. Tonight, the Planning Commission did receive this ordinance for their comments in October after Council made their action, and tonight is the first of at least two public meetings for the Planning Commission to discuss their thoughts and their comments on this ordinance, as well as seeking your perspectives as well in deliberating their recommendations or report. Westmoreland County has already submitted a report, which basically are comments, and the form of the report by the Planning Commission will be their choice, whether it be comments, concerns, questions, etc. What I'd like to do this evening, very briefly, I hope, is provide an overview of where we were, where we are, and what is coming up next. This is the map of Murrysville, and this has been the subject of a lot of discussion concerning where oil and gas drilling can occur. This map was produced as a result of the existing ordinance 833-11, which established an overlay district primarily over rural residential RR areas and also some B areas, and it was represented on the eastern side mostly and the southwest side of the municipality, as indicated on this map. There is no changes being proposed in the new ordinance or draft ordinance to this map. The overlay district will exist as written now, as exists in the 833-11. 833-11, as you may recall, was adopted in 2011 as the first response to concerns over how to deal with this new issue of Marcellus shale drilling. At that point in time, there was lots of confusion on what a municipality could do and could not do. And Murrysville kind of took the bull by the horn and said, here's what we think is the most appropriate direction municipality should go for this matter. Many public meetings were held, a task force was formed, the ordinance was developed, including, again, an overlay district. It was permitted as a conditional use, meaning the drilling activity. Application procedures were established, standards were established, setbacks were established, etc. This is what we know now as 833-11, or Section 220-31CC of the zoning ordinance, the existing regulations on oil and gas drilling. In the interim, after this adoption, the state of Pennsylvania adopted a piece of legislation called Act 13. Act 13, among many things, established new regulations on how DEP has to operate in issuing permits to drillers for unconventional and conventional drilling. Unconventional drilling, if you're not informed, is the deep Marcellus shale type drilling, where conventional is more the shallow well, or more the shallow wells. This Act, Act 13, also had parts of the Act which limited the ability of local municipalities to utilize their approaches on zoning to regulate this use. There were very prescriptive requirements on where it was permitted, everywhere basically, and how it could be processed. There was a challenge to Act 13, and Act sorry, I didn't move my slides here. There was a challenge to Act 13, and the Supreme Court ruled that the provisions in the Act 13, which limited the municipalities to exercise their zoning powers, did not prevail. And those sections were, among others, were removed from Act 13. As a result, Council in 2014 said, okay, let's relook at our ordinance. Let's examine how Act 13 decision in Robinson Township case affected our ability to regulate this use. And let's also examine any changes that have occurred in the industry, in studies, in trends, etc., so we can bring our ordinance up to date and provide it in a way that benefits and balances the rights of property owners as well as the general public health, safety, and welfare. This Robinson Township case had an impact, and certain tasks were assigned to a task force, which was reformed to deal with this issue. It included evaluating Robinson Township case, which we heard and studied and researched various legal opinions on Act 13, what it meant. We looked at the issue of what can we regulate and what can't we, and the conclusion was we can regulate where and procedures, but we can't regulate how, the operation. That's under DEP's jurisdiction. We looked at various approaches of where and options to the overlay, such as moving into a business district, which there was not enough area, enlarging or decreasing the overlay area, creating a new district, or rezoning different properties for this use. We explored these very intensively, and the conclusion was that the overlay approach was the most appropriate. And we looked at geospatial analysis, new mapping, to evaluate the impacts of proposed setbacks on the ability to have viable drill sites to meet our requirements under the planning code. We also looked at various studies, many studies, pro, con, We wanted to focus more on peer review studies. The state of Maryland, I know, was brought up in our previous meeting, and people say, why Maryland? Maryland was going through its own due diligence at that same time and preparing a analysis of what should they do in developing regulations for that state. And the conclusion was that some of the things were relevant, some of the things were not relevant to municipalities. But there were some framework issues, particularly information that was being requested would benefit an analysis of an application, such as a gas development plan, and also looking at the various peer-reviewed studies to determine what are the key issues or impacts that are important to a community in the operation of drilling. So we ended up here with our proposed ordinance, and this last line is capitalized, basically was to take all the information we digested and studied and to develop a new ordinance that best protects the public health, safety, and welfare of all the citizens of the municipality in a balanced manner that recognizes and protects property rights. So that was the goal of the development of this ordinance, to protect the property rights of leaseholders who have interest in operational aspects, goals in their own property, the drilling industry, as well as the public health, safety, and welfare. So the ordinance basically, in a nutshell, was broken down into various sections. It remains a conditional use, which means that it needs to go through additional requirements, both standards and public hearings, before council can consider granting approval of the operation of the site. It includes setbacks, and here there were some changes made. The original draft that was presented to council proposed a 750 feet setback from the edge of the structure, any protected structure, to the edge of a disturbed area, minimum of that setback. Council, in their deliberation, reduced this setback to 550 feet as part of the adoption of the resolution. And it also included a provision to increase the setback based on any unique characteristics of the site that are presented, justifiably presented, as being concerning at the public hearings. The ordinance also increased the buffer area yard requirement of the existing 833 provision of 200 feet to 250 feet from the edge of the well to the property lines, where no activity can occur. It's like a buffer area. The only activity that can occur in that area will be access road for vehicles utilizing the site. And it maintained the provision to allow for waivers of the setback provision. In a nutshell, here's the comparison between the current ordinance and the draft ordinance. The current ordinance is 600 feet. The proposed, as drafted now, is 550 from the edge of the property line to the structure, minimum. The state requirement under the Act 13 is 500 feet. The buffer area or yard area, existing ordinance 833, 200 feet from the property line. The proposed 250 feet. The state does not have a yard requirement or a zoning requirement like that.
No,
When he's done.
let him finish.
The total distance is 800 feet from the edge of the well pad to the protected structure under the existing ordinance, and with the revision to the 550, makes that 800 feet from the edge of the well pad to the protected structure. So as it's drafted right now, there's an equal amount of distance between the existing ordinance and the proposed new ordinance. The exception that under the draft ordinance was the ability to increase the setback based upon any findings at the hearing. This drawing here illustrates the setbacks and the buffer yards, with the exception that the 750 is still in there because that was the original draft. this 750 would change to 550. As you can see, under a site, there's a well pad shown here. There's the green area, which represents the yard requirement, or the buffer area, of 250 feet. And from that point, there's the measurement of the 550, which must be clear of any protected structure unless the owner waives their rights for protection. The two sides here are shown purposely that the 250 can be exactly 250, meaning it can be no less than 250 to the property line, or it can be more. But in no instance is it measured, no instance does it exceed 800 feet. In this case, it's a larger setback because of maybe the shape of the property. This is a good illustration, I believe, of showing the application of it. The other important provision that were added to the new ordinance were requirements for what's called a comprehensive gas development plan. The purpose of this plan is to lay out specifically the plans of the operator in terms of the connections to pipelines, in terms of traffic concerns and traffic routes, how is this all going to tie in, all the pieces. The drilling site by itself does not stand by itself. There are other aspects to the pipelines, to the compressing stations, etc. And how does this relate, how does the site relate to it? It also focuses on the environmental studies to demonstrate, as part of the findings and part of the fact finding of this application, that the environmental rights protection under the PA Constitution are covered in terms of impacts to the environment. And there, the request and requirement would be, show us a plan for water testing, show us a plan for air emissions, how you're going to reduce air emissions, not telling you how to do it, but saying, here's what we want to see in terms of the impact of this site, and show us how you're meeting your environmental responsibilities. This includes the environmental compliance plan and a risk assessment study, which is a standard industrial approach to saying how much risk is involved of an accident given the design and scenario of the operation. It also includes the community and environmental impact study, which is a requirement of all applications to the municipality of Murrysville under our charter. That would be submitted. A preparedness, prevention, and contingency plan, which is for emergency response, a noise management plan, and a traffic impact plan. The compressor stations and processing plants were pretty much handled the way it was in existing ordinance, with the exception of we did move these to the B district, because we feel that these are different uses than the drilling operations. The drilling operations are temporary uses with a temporary impact based upon construction activity, and the end use is a gas well, which is different than what's going on with the operational aspect of fracking. The compressor stations and processing plants are, in fact, undisputably industrial structures, and these belong in the B district, we felt, as opposed to in the overlay. Legal perspectives, there are many, and I'm not going to sit here as an attorney. I'm not an attorney, but I'm going to present some of the issues that we've discussed as we develop these ordinances with our attorney as well. The legal responsibility that we must provide for legitimate land use under our zoning ordinance. Unconventional drilling is a legitimate land use. It must be provided for. We cannot ban it. And we must provide for reasonable development of mineral resources under the MPC. We also must look at the impacts of the Robinson decision, including our ability to do this, again, for the use, for the site location and application requirements, demonstrate meeting conditional use, but also the fact that this is an industrial use, but the industrial use is part of the construction activity as opposed to the actual end use. And the industrial aspects of the uses are the use versus construction, as I just explained. And the application of the Environmental Rights Amendment, which is sort of the big 500-pound gorilla out there with many of the court cases that are coming up in most recent history. The Environmental Rights Amendment was utilized as justification or explanation by Chief Justice Castile as the rationale for overturning the provisions of Act 13, some of the provisions of Act 13, and the approach that was utilized there in their decision was that the state acted improperly. The state acted improperly when it enacted Act 13 in terms of the Environmental Rights Amendment. No comments were made in terms of localities. It was the state. The validity of the proposed zoning ordinance, we must make sure that our ordinance does not de facto exclude the use. And we're very judicious about this. Various mapping analysis have been done by with our GIS consultant, looking at these setbacks, both the 750 and now the 550, to try to make, and the buffer yard, to make sure that there is a sufficient amount of area that's available for these drilling sites. We're very aware and cognizant of our responsibility under both de jure and de facto exclusion and the consequences of that. And then there's ultimately a balancing test. Having the regulations, having a nexus between what we say we want to regulate to protect public health and safety, providing for the use, as well as providing for a rational plan of development to allow this use, but not to allow it in a way that protects the public health, safety, and welfare, as well as protecting the integrity of the community. I've been asked to present some new information on recent court cases, and this could be coming up almost every month from now as we move along, because many court cases have been filed. But some of the more recent ones I thought were relevant to present this evening to Planning Commission, including what case was decided in 2015 by Commonwealth Court, which dealt with, it was a case of the Pennsylvania Environmental Defense Foundation versus the Commonwealth. It dealt with drilling sites and state game lands and state lands, et cetera. But the thing that came out of it was it looked at the Robinson decision and decided the Environmental Rights Amendment analysis was just that. It was presented as a plurality decision, meaning that there were only 3 justices who consented with that. It was not established law and could not be utilized as binding or as precedent setting to rationalize the drilling areas of saying, well, you can't put it in the non-industrial areas because it violates the Environmental Rights Amendment. That could not be utilized as a defense under that approach. Very important case. And it also established something called the Payne test, which I'm not going to go into too much detail, but basically the Payne test is, this is going back to a case, Payne versus Gassah, back in the 70s, I believe, that established criteria for evaluating the Environmental Rights Amendment. And it's basically the court said that this is the criteria. If there's going to be a question of the Environmental Rights Amendment in a case, this is the criteria that should be utilized. Is there harm? Can the harm be addressed? And are the current regulations that are in place being met? It goes to the current regulations. In this case, many different interpretations on this case, what it means, but it could basically mean that whatever DEP says applies. So under this criteria. This case is being appealed, has been appealed to Supreme Court, and arguments will be heard early next year. Recently, in Westmoreland County, there was a case in Allegheny Township. Westmoreland County Court of Common Pleas, Judge McCormick, upheld a challenge to a township ordinance by Allegheny Township that permitted drilling in residential and agricultural areas, similar to the areas that Murrysville has established with its overlay. But in this case, almost 2/3 of the township was open to drilling. In Murrysville, the overlay is like 38% as a whole. So this is a lot more permissive. It was challenged by objectors. Bottom line, a lot of different arguments, but the bottom line, I think, is relevant to our ordinance and our approach moving forward, is it ruled against the application of the Environmental Rights Amendment as being an appropriate challenge to their ordinance. And it basically established the principle, or reestablished the principle, that the community was properly using its zoning authority. As long as the community uses its authority properly, the judge was not going to intervene in that. This is probably going to be appealed as well to Commonwealth Court. The other case is very similar. Middlesex Township, Butler County. The court upheld a challenge to the township ordinance that allowed drilling in approximately 90% or more of the lands in the township, zone residential, agricultural. Again, they ruled the non-applicability of the Environmental Rights Amendment. Sorry. So those are some of the current cases. As you will see, some of these cases seem to support our approaches here. Others may not. And that's why I purposely have the blank slide here of what's next with the cases. We'll be watching this over the next, I would say, couple of years to see exactly what the outcomes are. But as of a snapshot analysis, the courts seem to be leaning in a direction more of allowing the communities to determine on their own the land use decisions. What's next after the Planning Commission comes up with its recommendations or report, as well as the county has done that? This all goes to council. Council decides on a plan of action as far as holding a public hearing or hearings. And I'm sure there will be many hearings, many meetings, many discussions, being very judicious and very listening and very, very detailed in terms of providing for an ordinance that, again, meets that balance of the multiple interests that are out there. I hope I didn't take too long, but hopefully it helped.
Longest 3 minutes I can recall.
Thank you. I got wound up.
Thank you, Alan. Okay, just some general rules as to the way we'd like to conduct this meeting tonight. As Alan said, the Planning Commission has had no input into this ordinance. This is council and the task force developed this. It's been given us to have comments. Part of the process is to listen to the public, and that's what we're here to do tonight. What I believe that the wishes of the members of the Planning Commission is to listen to everyone tonight. We're going to rest and digest that, and then 2 weeks from now we will come back and discuss this at a public meeting, but it will be amongst ourselves that night. You're welcome to come. But we won't be taking any more testimony. Just so we can be productive here this evening, if you have comments, and I see a number of people have signed up, it would be very helpful if you could, if you have a thought, if you could refer to a specific section of the ordinance that you're addressing, because that's what we're not here to debate the virtues or pro or con of fracking and gas well drilling this evening. If you have some written backup material that you would like to give us, that would be greatly appreciated. We will read it, each of us. And this is not going to be a debate, so please be courteous to your other people who are speaking, and even though you may have a difference of opinion. We want to hear from everybody, but please try to keep your comments so they're not repetitious. I'm going to go down through the people that have signed up. If you didn't sign up, don't worry about it. I'll give you a period at the end for anyone who has not spoken. I'd like you to use one of the two microphones and give us your Your name and address is here, but if you haven't signed up, I will ask for that. So, that being said, I don't know who signed up here first. I think it's Kathy Baker. Did she sign up? Ms. Baker, you're at on Farm Road in Export.
Good evening, ladies and gentlemen. This proposed ordinance has many flaws and unreasonable requirements. One of them being Section 220, requiring that an applicant prove they will not violate the rights of citizens to clean air and water. You are, in effect, asking them to prove a negative, which you know is impossible. If you don't know that, I ask you to prove that it will. You don't know how to do that. It can't be done. You're requiring air modeling and hydrogeological studies be done. After much searching, and I looked, the only place I could even find a mention of this was in Texas. Why aren't you adhering to Pennsylvania law, land use law, which prohibits a zoning ordinance shifting the burden of representing evidence to general health, safety, or welfare to the applicant? The Pennsylvania State Act adequately addresses the issue of air and water quality. As Murrysville does have an additional ordinance currently in effect, why not start over? Do it on hard, provable facts, and let's use Pennsylvania law. This is where we live. Thank you.
Thank you, ma'am. Norman Frank of on Sardis Road.
Penny, can you move that microphone closer to the stand so they can be, I don't know if it's picking that up. Just move, yeah.
Okay.
Base, slide the whole base.
There you go.
Thank you.
Ready?
Yeah.
Okay.
Thank you.
It took the proposed ordinance 930-15 to wake up the Murrysville citizens. Previously, almost no one thought that the proposed regulations would be as restrictive as they are. Pro-drilling and fracking people turned out at the Murrysville Council meetings. The Murrysville citizens voted against the three anti-fracking candidates. State regulations are sufficient to provide for safe drilling and fracking of wells. The Beaver Run Reservoir wells are an example of this. Murrysville should adopt the state standard 500-foot setback from wellhead to a protected structure. The ordinance now has a well pad, a 250-foot buffer yard, a 550-foot clearance to a protected structure. This is about 1,000 feet instead of 500 feet the state has. The Oil and Gas Recovery Overlay District should be enlarged. The ordinance also requires a water withdrawal plan. The state issues these permits through the PA, EPA, not the municipality. These restrictions hurt the oil and gas right owners, many of which are Murrysville citizens. Murrysville should abandon the pending shale gas drilling ordinance. It's too restrictive. There's too much duplication of state-required regulation and reporting. We should just give Murrysville copies of the state reports, and that should suffice. Thank you.
Thank you. Bruce Livengood of Bollinger Road.
Thank you. I just want to make sure I'm clear about Mr. Cohen's presentation. If I'm understanding things correctly, according to Act 13, the setback is 500 feet from the borehole. And that's not quite the way it's presented at this particular time, if I'm correct.
That's correct. 500
Okay.
feet from the borehole.
From the borehole. Now, what you're saying is it originally started out as 750 feet. Now I guess it's down to 550 feet from the perimeter of the well site, plus the distance of 200 or 250 feet setback. Basically what you're saying is that now a structure can't be within 1,000 to 1,250 feet, if I'm understanding your numbers correctly.
No, first of all, the 250 feet is a setback from the property line.
But not from the borehole.
It's inclusive. It's from the edge of the well pad to a property line, can be no less than 250 feet.
Right. But that's different than the Act 13, which is 500 feet
Right.
from the borehole.
That's
that
correct. Act 13 is 550 from the borehole. 833-11, which is the existing ordinance, is also from the edge. It's not from the borehole. It's 600 feet from the outermost structure. That's the existing ordinance.
Is that what I understand? Is that correct?
Yes. Yes. 833-11 is measured 600 feet from, not from the borehole, well pad. It's from the edge, the last structure. Right.
Excuse me.
So,
We're not debating.
so the interpretation of my reading that ordinance, as a zoning officer, which I'm not here, but would be that you have a structure on the site, you have equipment on the site, the way it reads, that's where the measurement starts of the 600 feet in existing ordinance.
I think your point is that the state says from the borehole.
Borehole, right.
And
Exactly.
they're measuring from the furthest disturbed area.
Well, I guess there's been a lot of numbers thrown around in the last couple of months, and I think many of us are confused about what this actually means. I guess my biggest concern is that if this is put into place as it is, my impression is that this will almost double the distance that potentially a piece of property could be exempted from it. And that's a major concern I think a lot of people have. So
Right, okay.
I'll just leave it at that.
Appreciate that, and
Thank
that's
you.
not the intent. The intent is the 800 feet as illustrated on the map we showed.
Okay, thank you.
Okay. Thomas Perret, do I have that correct?
Okay, thank you very much for all of your hard work. I realize that probably a lot of hours go into what you've done that we don't know about, and we appreciate your efforts. I've addressed the council a couple of times in my regards to, first off, I am president of Free Gospel Bible Institute, and I oversee 75 acres, all of which are in the oil and gas recovery zone. And as far as the ordinance goes, what I've stated to them as a whole is that we feel like the council has already adopted the maximum amount of protection for those that are not in the oil and gas recovery zone by putting them in a non-recovery zone. And what we're asking the council and asking you as part of the Planning Commission as property owners is to give us maximum liberty to develop our properties according to our rights as American citizens, citizens of Pennsylvania, citizens of Murrysville. And I think one of the things that greatly disturbs us is the way that these dimensions are being drawn. Again, as the last speaker said, the state of Pennsylvania is drawn from the borehole. Now it's from the furthest extremity of the pad, which in essence requires us to get either a waiver and permission from people that live, only math tells the answer, whether it's a quarter of a mile or more from our property, to adequately develop our property. And as property owners, we want you as the Planning Committee, and I'm speaking for myself, anyone else that would agree with that, to please consider our rights. We feel like those in the non-drilling zone have been maximally protected. Give us maximum liberty through your influence to develop our property just like they're given maximum protection. That's what I've got to say. Thank you.
Thank you, sir. Am I pronouncing your last name right? It's Perret? Peredic. Oh, okay, it's I-C. Okay, very good. Thank you, sir. Bob Cipher on Weistertown Road.
Gentlemen, planning board. First of all, I say I have no professional speaking lessons or anything like that. But I'm not here to question lines and paragraphs. And you, the way this is set up with the council and you are a checkpoint. And I hope that the people here will realize that what somebody has done on council, and there were some issues there, but what they've done and sent on to you, I hope you can understand and see that it's too restrictive for your residents that have the ability to market some gas, and I might say for the Murrysville Community Park. And I have a note here that I'm going to read, but I want to speak to you about the logo behind you in 1878. Now, I understand that you weren't the first because they couldn't locate the actual drill site there. So it's not a national treasure or whatever, okay? There were 2 wells drilled in Pennsylvania in 1872. They weren't drilled. I think they were dug by hand, if you can imagine that. This well here was 1,460 feet, roughly. And the crazy part is that it flumed for 3 years, it says, because they had no experience, okay? So Murrysville has had experience with gas wells since 1878. You've had them here. I guess there's one by some of your schools and so forth, okay? How many catastrophes and how many bad things have happened that any of you can remember that's happened in Murrysville with a gas well? I've never heard of any. But evidently, it's going to happen, or it did happen somewhere. And I think it's just crazy. So the part of this is, first of all, the money end of this. Council has taken it upon themselves to decide that they're not going to accept for the park, Murrysville only, we're looking at 312 acres. They're not going to accept any money for that. They're not interested. Well, you're talking right off the bat an easy $750,000 to $1 million. So 7 people on council decided that for us. And I think, and this is only the signing deal of the lease. The drilling and no drilling on the park itself. It would be off-site. It's going to be horizontal. They're down to 7,000 or 8,000 feet and horizontal up to 10,000. So it's not going to be around the park. But the council's decided that $1 million or 3 to 4 million over 6 or 8 years, or maybe 10 years, is something they're not interested in. I have a problem with that as a taxpayer. The other thing I have a problem with, and as a landowner, excuse me, we're all taxpayers in Murrysville, okay? And by the way, you operate this like a business, okay? But your product is the people. The people of Murrysville are your product. And they have to get the money to pay the taxes somewhere. Now, it's the same if you rent. You have people come in here that have no land at all. They come in here, they're going to rent. They're going to come up and talk to you about, I do want it or I don't want it. That's fine because their rent's going to a structure and they're going to pay school tax and property tax. So everybody has a say-so, but by the same token, they can't turn down this money with 7 people and speak for all of us for what it could do to the park. And when they do it, they accept the money for the park. And by the way, the state of Pennsylvania, here's what I want you to do. The state of Pennsylvania, what they recommend is plenty good. It's good for everybody. They've done this. They don't have to go and research it again. Here, the third oldest gas well in commercial gas well in the United States, so we're going to Maryland and trying to see what they're coming up with. The only gas wells they could have would be down around Deep Creek because there's no gas east of there. So, you know, this is craziness. It just doesn't make any sense. So what I want you to say is that the restriction that what they came up with, what do you call this, a doctrine or whatever the heck it is, it's too restrictive for the people, the landowners that have an opportunity to do this, and for them to turn down the money for the park, the 7 of them or whatever. And one of them has a gas lease. He shouldn't even been able to vote. Another guy on the board did recuse himself but the other guy has a gas lease with Huntley, and he shouldn't have been allowed to vote no matter which direction he went. So I've got a problem with that too. So the other part about this is, you know, just to show you, ooh, this is fracking or whatever. Look at your gas prices. How many here in this room had their turkey cooked on Thanksgiving on a gas range? Okay, how many of you? All right, it's America. It's an American resource, and it's gasoline at this natural. We're talking natural gas, but gasoline at the pumps are the cheapest they've ever been. We've got to develop this resource, keep the money in the United States, not send it to the Middle East. One other thing.
Should last one more thing, sir.
Pearl Harbor, okay? December 7th. I happened to be in Saipan a month ago. The story about Saipan is that there was a fierce battle, and the Imperial Japanese Army was told they fight to the last man, no surrendering. Well, during this process of us getting over there, it happened December 7th, 1941. In 1944, we went to Saipan as the American troops, kids 19, 20, 21 years old, and they fought and died on both sides, thousands of them. But at the end, when we were, it was obvious, the Imperial government said, no surrendering, fight to the death. There's a big cliff there. They went over and they all jumped off, but the point I want to make is that they had so indoctrinated the people that were indigenous to the island, the natives, that they told them how bad we were, okay? And what would happen if we took over. Something like the fracking and the people, the bad stories here, the native women took their kids by the hand and their babies in their arm, and they all jumped over the cliff. That's what is going on right here.
Okay.
Thank you.
Thank you, sir. Paul Burke from on Pleasant Valley Road.
Thank you. If I may.
M&A on public speaking.
He did good. He did very well.
I prepared some materials for you. I've reviewed the Marcellus Task Force recommendations. There's a lot of information there, but I don't know that they had all the information that's available with regard to environmental studies.
Thank you.
That have been done in the Commonwealth of Pennsylvania as well as other states. Other information. There's the recent electoral campaign. I think the environment, the atmosphere got rather heated, and there was a lot of disinformation out there with regard to what happens when drilling these wells. And so I just took the opportunity to try and put together some material for you. Oh, I pass them down. I'm sure I'll save you some of that.
It's like War and Peace.
Now, I expect you all to read these next week. It'll be a quiz.
Thank you.
You're not going swimming with
Somehow I knew that was coming.
Wake him up.
Yeah.
One more? All right. The point of all the information in there is to address the extreme overreach that I see has occurred with this proposed ordinance. The setback requirements, several people have talked to you about that, and they basically said that the effective result of that is basically 1,000 feet from the well bore as compared to the 500 feet required by the Commonwealth of Pennsylvania. Now, the 500 feet developed by the Commonwealth of Pennsylvania was not a number that was picked out of thin air. Those numbers are developed, and that research and those regulations are developed in conjunction with what's known as the Technical Advisory Board. And these are industry experts, environmental experts, that provide recommendations to the Pennsylvania Department of Environmental Protection. So that 500-foot setback requirement is there after analysis of safety, environmental, engineering studies. That's why it's there. So why do we need a further setback? What's the justification for that? I don't know. I don't know. It sounds good, but where is it? Where's the justification for it? In this ordinance or in the recommendations of Marcellus Task Force that we're looking at here? In fact, you know, we talk about it being a 1,000-foot setback, all right? And if you look at the report, the recommendations of the Marcellus Task Force, they even admit in there that it was found that as the setback increases beyond 800 feet, potential areas for drilling are depleted to a minuscule level. It's an admission in their own documents as what's going on here. The purpose of this ordinance is not for the constructive development and effective development of this natural resource. It's to stop it. That's the bottom line here. To build up restrictions upon restrictions upon restrictions. Let me go on and point out a few other things. There are a number of other things that are problems with this, and I'll go with some specific items. There's a requirement in here for a water withdrawal plan. It requires that an applicant provide a water withdrawal plan identifying the source of water, how many gallons will be used, withdrawn each day, the origin of the water proposed, truck routes, and all withdrawal permits issued by the Commonwealth of Pennsylvania. Water withdrawal plans for oil and gas well sites are regulated by the Pennsylvania Clean Streams Law in Section 3211M of the Oil and Gas Act. All water withdrawal plans are required to be approved by the Pennsylvania Department of Environmental Protection. To the extent that this ordinance, which it does, imposes requirements beyond those mandated by Chapter 32 of Act 13, it's preempted by Section 3302 of the Oil and Gas Act. You can take a look at Range Resource Appalachia LLC versus Salem Township, a lawsuit just down the road that established this principle. Disposal plan. The proposed ordinance requires an applicant to present a plan identifying the means and availability of the site for disposal of cuttings, fracturing fluids, oil, toxic materials, hazardous materials, and other waste products. That's in Section 220-31 C, subparagraph 6, paragraph B, subparagraph 5D. Again, the Pennsylvania Department of Environmental Protection has exclusive jurisdiction over the planning and regulation of solid waste storage, collection, transportation, processing, treatment, and disposal under the Pennsylvania Solid Waste Management Act. For any fluid being disposed of from an oil or gas well site, DEP has jurisdiction over the manner of disposal under the Pennsylvania Clean Streams Law. DEP regulations expressly address control and disposal planning by well operators, and that's all set forth, for example, in 25 PA Code Section 78.55. Local regulation, which is what you're trying to do here, is preempted. It's not valid. Air emission plan. Someone mentioned this. The proposed ordinance requires an applicant provide a plan prepared by an environmental engineer demonstrating methods utilized to reduce emissions into the air from activities conducted within the well pad site. And that's Section 220-31 C 6B5H. Again, regulation of air emissions is within exclusive regulatory authority of the DEP. Local government regulation of the same is preempted by the Pennsylvania Air Pollution Control Act. I would ask, as a practical matter, even if I were to submit a plan, who here is at the municipality is equipped with the technical knowledge and expertise to tell me whether my plan is any good or not? Who has the expertise? You're going to hire consultants to do that? You're going to add more personnel to take care of this stuff. The DEP, they got a whole staff that do this. Water testing, soil survey. The proposed ordinance requires extensive pre- and post-development water and soil testing and monitoring. That's in Section 220-31 C8. Section 3218 of the Oil and Gas Act provides for the protection of public and private water supplies from pollution or diminution by well operators, both conventional and unconventional wells, including the rebuttable presumption for pollution to a water supply and an operator's defenses thereto. The proposed water survey requirements are clearly preempted by state law and regulation in that regard. They also violate Section 3302 of the Oil and Gas Act by singling out the oil and gas industry for different treatment than other uses. I could put a quarry in your drill zone easier than I can put a well. What's the environmental impact of a quarry or a coal mine compared to a well? It's minuscule. It's not even comparable. And yet the way this is structured, you're putting all these burdens on one industry. Again, for what rationale? What reason is there for all this? Ponds and pits. Truly, probably not a big deal, but the proposed ordinance requires an applicant to demonstrate why a closed-loop system is not feasible. It also prohibits impoundments as a standalone principal use and prohibits the use of surface aerators. aerators. These requirements clearly relate to the operational features of oil and gas operation, and therefore are preempted by Section 3302 of the Oil and Gas Act. Someone also mentioned this about demonstrating compliance with the Environmental Rights Amendment and demonstrating that the development will not violate the rights of the citizens of the municipality of Murrysville to clean air and pure water set forth in Article 1, Section 27 of the Pennsylvania Constitution. Okay? As a larger question, I would ask if anyone here has ever had a breath of clean air in their life. I haven't. I grew up in a rural area. Did anyone ever have pure water? There's no such thing as pure water. So what are the standards? The standards are the standards. What are the standards? Every municipality going to have their standards for clean air and pure water? Or are we going to have, which would be total madness? Or are we going to look at standards based on a statewide level? Standards that are established under the Clean Streams Act or the Air Quality Act of the Commonwealth of Pennsylvania, where you have expertise who can do the analysis, study of what constitutes clean air and pure water. Putting that aside, that section places upon an applicant the burden to demonstrate that its operations will not adversely affect the health, safety, or welfare of the citizens of Murrysville, and mandates that the applicant submit reports from qualified environmental experts attesting that the proposed environment will not negatively impact the municipality's residents' environmental rights and will include air modeling and hydrogeological studies identifying potential pathways that a spill or release of fluid may follow. Okay. These provisions, I submit, are in direct contravention of the long-established Pennsylvania land use law principle that a zoning ordinance cannot shift the burden of presenting evidence as to general health, safety, or welfare requirements to an applicant. For that proposition, I would cite you to the case of Gray versus Zoning Board of Adjustment, 410 Atlantic 2nd, 909, Pennsylvania Commonwealth Court, 1980. Moreover, the proposed ordinance does not even explain what air modeling and hydrogeological studies are. Again, getting back, local regulation of air emissions is preempted by the Pennsylvania Air Pollution Control Act, and local regulation of water quality is preempted by Section 3218 of the Oil and Gas Act. Mr. Cohen cited, I would say with pride, the requirement that there be a gas transmission plan required in order to get a drilling permit in this municipality. Sounds good in theory, totally ignorant of how the industry works. First off, the industry is segmented. If I work for an exploration and production company, we explore and produce the gas. The gas is taken to the market, to the transmission lines, by an independent third party, usually, in the vast majority of cases. It's called a midstream company. The midstream company is not going to have their plan for their pipelines to get the gas to market prior to any wells being drilled. There has to be a critical mass of a project for them to invest their money in putting a midstream together. It's impossible for anybody to meet that requirement. It just is an example of how a lack of industry involvement and expertise in the process results in bad legislation. Risk assessment report. Proposed ordinance requires submission of a risk assessment report prepared by an expert in the field, identifying the potential hazards stemming from oil and gas development within 1 mile of the well site. The report shall also include a list of best management practices to address and mitigate identified hazards and harmful health effects. That's in Section 220-31 CC 6B5J. To the extent such a report addresses air, water, and other issues regulated by the DEP and other state agencies, or singles out the oil and gas industry for treatment different than all other uses, this section is preempted. Is there, I looked on the website for the municipality, I don't know if there is an example of a report, or does the municipality even have a qualified staff available to even evaluate the efficacy of such a report were to be submitted. Again, there's a practical, technical issue here that I don't think that's been thought through on behalf of the municipality. Traffic controls. Proposed ordinance, among other things, provides that the municipality can designate the routes used to access the development site, and that an operator can only use municipal roads when state roads are not feasible. It also apparently requires a roadway maintenance and repair agreement for all municipal roads that will be used. The company that I work for is Huntley Huntley. I'm their vice president and general counsel. We strive to minimize impacts on both local and state roads. But the municipality only has the authority to regulate the operation of overweight vehicles on roads which have been properly weight restricted after an engineering study, ordinance, and posting of signs was required by the Pennsylvania Vehicle Code. That's the 75 PA Consolidated Statute, Section 4902A and B. The municipality cannot mandate an oil and gas operator or any other user only operate on state roads. The proposed ordinance also requires an applicant provide a traffic control plan that conforms with PennDOT standards. PennDOT requires the development of traffic control plans only for work occurring in or near highways where workers or equipment will encroach in the roadway and interfere with the normal flow of traffic. Those are set forth in PennDOT Publication 213, Temporary Traffic Control Guidelines, and PennDOT Publication 408, Section 900, Traffic Accommodation and Control. Neither publication is applicable to traffic created by a new or more intense use, so these publications appear not to be applicable to well-site traffic at all. So what you're citing us to comply with doesn't make any sense. There's a lighting requirement. The proposed ordinance, and this is in Section 220-31CC9B, requires that lumen levels shall not exceed 0-foot candle at the property line. That sounds crazy to you? It's totally crazy to me, because it's simply put, it's an unreasonable and probably impossible standard for any user to meet. 0 lumens. You get more than that from the moon.
Anything else, Mr. Burke?
I could talk about the oil and gas development facility, compressor stations. They're permitted only in the B business district as a conditional use. If you look at the map, the area of development is way out here. The compressor can only be in there. No way to get there. It's basically exclusionary on that basis. The bottom line here is that this ordinance, this proposed ordinance, is, frankly, in my opinion, as a citizen of this township, with a property owner who wants to see his resource developed. I have some acreage here. It's ill-conceived, it's ill-advised, and I don't know what is wrong with the current ordinance you already have. It's very restrictive as it is. They even admit, as I cited before, with those setback requirements, the Marcellus Task Force, in their recommendation, even acknowledged the fact that if you get beyond 800 feet, it's minuscule. If you consider simply the setback, plus the requirements of the state setbacks for an erosion and sedimentation control general permit 2, which I don't think was considered in looking at this, when you overlay all those restrictions by the state with these restrictions, you're pretty much eliminating any development here in the municipality, and you're taking away people's rights for no good reason. There's nothing going to be accomplished here on behalf of this municipality by passing this ordinance, besides taking away people's rights to develop their property. And it's just wrong. Thank you, sir.
Cindy DeSalle from Boy Farm Court.
Well, I was all set to talk about traffic and lighting, but Mr. Burke kind of took care of all that for me. So I would just like to make a comment on what Mr. Cohen said. He felt that the ordinance was balanced in protecting the rights of all the residents. I feel it is very unbalanced and does not protect the rights of private property owners and our right to develop our land how we see fit. I had a lot of time to review the ordinance while I've been recouping, and I really do find it so repetitive and so manipulative in positioning Murrysville to, in essence, put a ban on all drilling of Marcellus shale wells, and I just don't think that's right. And I would like a recommendation to be made to scrap this proposed ordinance and let's start again. And I would love to be on the task force for that, to start all over again and start from scratch and get some industry people involved in the input. Thank you.
Thank you. Chris Nestor, Martinsburg, VA.
I'll explain. My name's Chris Nestor. I'm an attorney, and I'm here tonight on behalf of several landowners in the municipality who are opposed to this oil and gas ordinance. My clients are Mr. Cipher, who spoke already tonight, Randall Steele, Darren Pulisic, Brian Brush, Jim Tobin, and David and Cindy Giswali. Ms. Giswali just spoke. We can spend a lot of time going through the legality of this ordinance. Your task force purports to have done it, but sort of let's peel this back, because your job as a planning commission is to make recommendations to the council. Your job is to ask the hard questions. Force the council to answer the hard questions about this ordinance. Unless you recommend that they do that, this ordinance will get passed, because I tell you, I'm surprised that the first comment that I heard from this planning commission tonight is, we had no input on this ordinance. That's frightening. You are the planning commission. It's your job to have input on this ordinance, but now it's been drafted, now it's been through council, and now you're being asked to make recommendations. Why weren't you involved at the get-go? Somebody else was, an outsider, but you weren't. I'd take offense to that if I was a resident of this municipality. But let's peel it back a little bit, because you have to answer the hard questions. You have to answer the hard questions and put them to the council. What is the authority for Murrysville to adopt an ordinance like this? It's not the Home Rule Charter. It's the municipality's planning code. They have to have statutory authority to do it. That comes from the MPC. Doesn't matter if you're a home rule municipality. It has to come from the MPC. What does the MPC entitle you to do? It entitles you to adopt a zoning ordinance. Not an operational ordinance, not an ordinance that regulates business operations, aspects of businesses. It allows you, as Mr. Cohen said, to adopt an ordinance that regulates the where, not the how. Pick up this ordinance and take a look at it. Other than the overlay district and the setbacks, what about this ordinance regulates the where? The rest of it is all operational. It all goes to the operational aspects of oil and gas development, not where it should be located. There's a lot of talk about Article 1, Section 27 in this ordinance and the whereas clauses and whatnot. That is not a source of authority for this municipality to act. At most, it tempers authority that you have by statute from the General Assembly. The only statutory provision being the municipality's planning code. That's it. And your scope of your authority, again, under the MPC is limited. It is limited to zoning. Keep that in mind. What aspects of this ordinance are zoning and what is operational? When you move past the authority, you have to ask yourself, okay, let's assume I have the authority to adopt this ordinance. What aspects of it might be preempted by state law or federal law? I would put to you that this ordinance, which comprehensively regulates oil and gas operations here in this municipality, is entirely preempted under existing Pennsylvania Supreme Court precedent. But even if not entirely preempted, massive portions of this ordinance are operational in nature and are preempted under binding Pennsylvania Supreme Court case law in this state. The Robinson Township plurality decision notwithstanding, which we heard a lot about and which there seems to be a great deal of focus on. Let's assume we get past preemption. Ask yourself, is this a reasonable limitation on the property owner's rights here in this municipality? Is this ordinance exclusionary on its face or as applied? I guarantee you, as applied, it is exclusionary. When you put the setbacks in place and the other requirements that are required by the environmental statutes or regulations here in Pennsylvania, you can't develop oil and gas rights in this municipality if this ordinance is applied. The little green circles that you'll see all over your maps, they'll cover the municipality. Does this ordinance as a whole allow for reasonable development of minerals in Murrysville? No, because it's exclusionary. Does it result in disparate treatment of similar landowners without a reasonable basis for such disparate treatment? You bet it does. What other industries in this municipality are subject to the requirements that are in this proposed ordinance? None. Is it unduly restrictive? Absolutely, as it pertains to oil and gas development. Does it result in a de facto taking? If I own oil and gas rights in this municipality, you adopt this ordinance, I can't develop them. You tell me. But you need to ask yourself additional questions beyond those. Put it back to the council. What's the basis for the setback? What studies did they do? What justifies the setbacks? Why are you measuring the setbacks from the outer perimeter of a well pad and the property boundary versus the wellbore, which is the only thing left at the end of the day once the site is developed? Why are you focusing on construction as opposed to the end use? Mr. Cohen said it. The end use here is the gas well producing, not the construction activity, which is temporary. Why then are we zoning the temporary construction? When somebody builds a shopping mall, are we zoning the temporary construction of the shopping mall? Somebody builds a factory. Are we zoning the temporary construction of the factory? No. You're zoning the end use. But that's not what this ordinance does. By what authority is the municipality imposing requirements for pre- and post-water quality and soil studies? Where's that in the MPC? What are you going to do with the data once you get it? What's the purpose? Now, Mr. Burke pointed out this provision about the demonstrate compliance with the Environmental Rights Amendment. I'd love to know who drafted this ordinance, because I'd like to ask that person what that means and what the standards are. Because I guarantee you, if I took each one of you in a room separately and asked you, how do I comply with that provision, I would get 7 different answers. Yet, the city council wants to impose that requirement on the regulated community. Think about that. As you go through this ordinance and you make your recommendations back to the council, ask those hard questions. Put it back to the council to answer them at a public meeting. Thank you.
Thank you, Mr. Nestor. Sam Staymates at Round Top Road.
I don't have nothing like that.
That's all right, Sam. You're a local boy.
Well then.
I've been to the last couple meetings there, and I've heard a lot of people's opinions and voices, and I think Murrysville voters voiced their opinions the beginning of November when we're going to get a few new people on council, and maybe we can go somewhere with that. That's all I got.
Thank you, sir. Doug Benish on Hills Church Road.
Good evening. I just got a few quick things. We're hearing a lot of opinions and emotions over the pros and cons of drilling. None of them are supported by facts. When you start doing the facts and the research, like one gentleman said earlier, we've been drilling since 1878. Shallow, we're starting to get into the deep stuff. This regulation is burdensome to those that have property and land. I graduated with Mr. Gwynn, who's now the commissioner of Penn Township, and as we know, there's a lot of drilling there, and had a conversation with him a few weeks back. Because of the high emotion and the opinions and the lack of facts that support some of the people that are against the drilling, they chose to stay with Act 13, Pennsylvania state law. That way, it kind of keeps them in the clear, and it keeps them clean in the future. I don't know why we're not doing the same thing. It's a great resource that we have here in western Pennsylvania. It's great for the economy. It's great for jobs. It's great for a tax base. It's great for our communities. We are drilling. I've heard a lot about water and air quality. We are drilling. They've already drilled in Beaver Run Reservoir. That is where our drinking water comes from. IUP has studied it for 4 years. There's all kinds of printed stuff you can get on it. I'm not sure why we're having this whole conversation. Thank you.
Thank you, sir. Mike Hillebrand from, where do you live, Mike? Thank you.
Excuse me? No, it's okay. Hi, Council. We're blessed with Murrysville having a bunch of intelligent people at all spectrums of ways of life, and this subject is a very difficult one. I'm a petroleum engineer. I've been doing this all my life, and I'm always willing to learn new perspectives and new thoughts to doing things better than the way we already do them. But I think with a certain bit of intelligence in our community becomes a bit of arrogance, and I think what I have seen so far is we all don't know what we don't know. And you're all sitting up there trying to educate yourself a ton to a very difficult subject. Council's been trying to do the same. There's been task force, there's been propaganda, there's been flyers, there's been a lot of information flowing out. And to me, who sits on the side, who admits I don't know it all in this industry, I know quite a bit. And I've been directly involved, and I care very much about what goes on in this community. I have kids that go to school here. I walk the parks. My wife is a lifelong resident of Murrysville, and appropriate land use can be defined in many ways, but the reality is that the industry can only do certain things in certain communities, regulated or not, by local zoning. And I think what this subject begs for is a ton of education and a ton of idea swapping back and forth from those who may or may not have legitimate input to the table to bring. And to go down the path of bringing law that introduces the challenges of this community, that walks us down a very fine line that I am familiar with, of saying you're going to be challenged, community. And our taxpayers that have already sponsored and paid a lot of this study are now going to be into a situation where you're going to be challenged. Why are we taking that course on? I can testify that the first ordinance, we worked for 3.5 years to try to achieve minimal use under a very restrictive ordinance that's been our resume applied everywhere in using local ordinances. And the one we had on the books was extremely restrictive and difficult to work with. And the one that we have now didn't pull any low punches and submit applications prior to this whole discussion going on. We didn't do that. We gave our word that we wouldn't, and we have not. But I can tell you I'm on complete hold with doing anything in Murrysville until we figure out a future of how this thing's going to work, because I can't function as an operations guy under the regulations that I see right now in front of us. That's a serious risk for this community, because you're dealing with a developer who understands the desires and the land use of this community, that others may not take that same approach as we come about in the tolerance of what this community begs for, and that's education. So I challenge a forum to how we get that education out there, how we get a debate going between those who are concerned, those who may have information that are right, wrong, or indifferent, and share the discussion so that we can all grow better to what we're trying to achieve, and that is safe development, environmental protection of people's resources that we're just the proxy of, the developer of oil and gas. And I have just one bullet to say relative to the where and the how. There is a very serious debate. I served as an advisor to TAB in the writing of Act 13 as part of my resume. And in the debate of 500-foot setback was a ton of how, not where. And so when this thing went to the Supreme Court and back under the where, I think there is a serious debate that, okay, zoning can say where, and zoning in typical stances has setback issues within zoning. If you determine how far back away from this or that or the other thing for zoning this area to that comes natural with NPC planning and zoning. And there has been a lot of discussion within TAB as the right of Act 13 came about of why there is a 500-foot setback to the how. And professionals around the world to emergency response were involved. All of that was vetted and fitted within this 500-foot setback that didn't come out of the sky, but was determined that that is a safe setback, no waivers, no tolerances, 500 feet is it, no sign-offs. And while that's been tried to be expanded throughout communities, 600 feet, and now we're approaching a lot further, there's been a bit of tolerance of the industry on that discussion of how and where. And I would argue that if we start getting too far past 500 feet, you're going to start getting into the debate of how. and that is not your jurisdiction, the where is. We can appreciate that within planning and zoning, that sometimes that setback distance comes into play and is a discussion. In this case, you got to look beyond that for what I'm talking about. The industry has vetted and has discussed the how of 500-foot setback, that if it keeps getting more and more expansive, I promise you, one day it will go back to the Supreme Court under a Huntley-type ruling that happened with Oakmont, that, okay, you said where, okay, this is the where, but setbacks are determined by whom? And that's a huge question, and it's baited right now for a test right here with the kind of setback language that we have. Education is the key, guys. I don't know what the answer is, but I invite forums and debate, and we're more than willing to be part of that conversation. Thank you.
Thank you. That is all who have signed up to speak. Is there anyone who hasn't spoken that would like an opportunity to? No? Thank you. All right, Penny, here's the list of speakers. I believe that we will take all of these comments under advisement. I don't know that I'm going to get through all of this by the next meeting, but it's a great resource, I'm sure.
We can't handle the overtime pay.
But we will be discussing this as a planning commission, and be trying to make a recommendation on December 16th, 15th. 15th. That's the third, 2 Tuesdays from now. So I thank you all for coming.
Thank you.
Keep in mind that, as we have stated earlier, our comments will go to council, and council will be taking this up, I assume, after the first of the year. Yes?
I just want to echo Mr. Hildebrand's comments. Echo, education is the key.
Absolutely.
And
Is there a
motion to adjourn?
I'll make a motion to adjourn.
We
Move
plan,
second. All those in
we
favor
plan to
say
have.
aye.
I didn't finish.
Thank you.
No, we're not finished.
Never mind. We plan to have programs on that. Thank you.
Alan was still talking.
Next week, I think, I didn't bring it up tonight.
Alan was still talking.
Oh, I'm sorry.
Tony.
I'm sorry.
Tony.
Alan.
Thanks for coming out.
The copies?
Yeah. Well, hey, we're here Tuesday nights a month.
Oh, this ordinance?
Hey,
Let's
Alan.
Yes, you can
That's
request
when you
that.
guys come out. I'm glad to see you out here, though. And